you in the room know much about her and associate her with her careful balancing of the interests of various stakeholders in the NFL concussion case. As an economist, it seemed to me that you faced a sort of present value problem, how to assess future damages, illnesses that may develop sometime in the future, along with potential positive treatments that might mitigate damages, and arrive at an award that is fair to all parties. This case, therefore, engages questions of how legal rulings adapt to these changes in science. When the selection committee identified Judge Brody as our recipient, it focused on this kind of inherent uncertainty of not being able to read the future with current science, but being asked to rule today. So that is the broader topic that we're going to be discussing this afternoon. We regret that one of our panelists, Anita Farahaney of Duke, was not able to be here today as her father fell seriously ill this week. If that is the bad news, the good news is that we have the opportunity of a deep dive conversation with Stephen Morse and Nancy Gertner. When our panel spoke by phone last Monday, Stephen lamented the difficulty of addressing this complex question in his allotted 10 minutes. Stephen, we're so happy to give you roughly twice that time, and then to engage in a dialogue with Nancy Gertner before opening questions to the floor. And as my students know, I'll call on you if you do not have questions. But I've heard this group before, and I'm pretty certain that there will be great questions. Nancy will add a little bit to my introduction of Professor Morse, but Stephen Morse of the University of Pennsylvania works on problems of individual responsibility and agency. With numerous interdisciplinary articles and chapters, he was a contributing author to Crime and Culpability, a Theory of Criminal Law. He's working on a new book that you can ask him about in the break after this, entitled Desert and Disease, Responsibility and Social Control. Dessert, oh, I like dessert, right? Morse was co-director of the MacArthur Foundation Law and Neuroscience Project, is diplomat in forensic psychology at the American Board of Professional Psychology, a past president of Division 41 of the American Psychological Association. His honors go on and on. Our panel will be moderated by the Honorable Nancy Gertner. Judge Gertner was appointed to the bench in 1994 by President Clinton, a courageous act by Clinton in that this judge, who liked to dress in a fiery red outfit, and I didn't know what she was wearing today, had made a name for herself as an advocate for women's right to choose. On the bench, she crafted compelling decisions dealing with race in the public schools, fair housing, and employment discrimination. Judge Gertner retired from the bench in 2011 and became part of the faculty at Harvard Law School. Not quite sure how Yale let you go, but teaching a number of subjects including criminal law, criminal procedure, forensic science, and sentencing. She continues to teach and write about women's issues as a now retired judge who had served as the U.S. District Court Judge for the District of Massachusetts. We're very proud that you yourself were a Brody Award winner, recognized for your work as a pathbreaker on women's issues. And I personally am extremely grateful to you because I know, again, as an economist, your opportunity cost of being here tonight was to instead be on CNN for your New York Times editorial that ran this week. So you can all check that out in the break too. So please join me in welcoming Judge Gertner and Professor Morse to the stage, and I'm sure you're in for a great evening. Thank you.
2 minutes.
Yeah, sure. Thank you.
I am starting only because I know Stephen Morse, and I know that if I don't say a few words, I'll never get a word in edgewise. Isn't that true? That's true. I just wanted to frame the issue a bit that we'll talk about today. Criminal law has obviously deals with mens rea, state of mind. And as a judge, one would oftentimes say to the jury, you can't look inside someone's brain. You have to determine intent, mens rea, by inferentially, by circumstantial evidence. And that, we would just intone that. One way of looking at the new neuroscience is that it purports, I say purports, to do just what we said couldn't be done, which was to look inside the brain. That essentially it is purporting to describe what is actually going on in a live brain, not afterwards, not before. And of course, that's not completely true, or true at all. There's substantial promise to the new neuroscience and substantial limitations. The course I teach at Harvard, I teach law and neuroscience, not because I remotely pretend that I'm a neuroscientist, but I'm a translator. One of the things that an advocate does and a judge does is to translate. So the course is set up where we invite neuroscientists whose work is supposed to be bearing, or they believe will bear on legal issues, and we ask the students to learn how to ask the right questions, much as a judge would have to do, to learn how to be critical. And the neuroscience also functions in a way like learning a new language does. Sometimes when you learn a new language, you know your own better, and it functions as a way of understanding more crisply what the legal requirements of criminal law are. One presenter, for example, a few days ago, destroyed the law of provocation by saying that there is no such thing as being overwhelmed with emotions, as if there is a pod in the brain for emotions and a pod for rationality, and the emotional pod overwhelms the other. Cognitive thinking involves emotions. Emotions invariably involve similar parts of the brain. There's no such thing. At the end of the class, you said, and exactly then what are we doing in criminal law? Another scientist spoke to the class, and he had exactly the opposite view. He believed that neuroscience could be reduced to categories which would map directly onto criminal law categories if only we would ask the right questions. So the purpose of today, in a very short amount of time with the very best interlocutor you could have, is to separate the wheat from the chaff. And there's no better separator of wheat and chaff than is Professor Stephen Morse. What is interesting about his background is that on the one hand, he has been in the MacArthur, the extraordinary movement that the MacArthur sort of presided over, the MacArthur Foundation presided over to address the relationship between law and neuroscience, but he is also a neuroskeptic. He also comes to the table with both an appreciation of the possibilities of the neuroscience and a profound understanding of their limitation. And while I will try to speak after he does, I doubt very much if there will be time. Stephen.
Good afternoon, everybody. I would like to thank the Goldfarb Center for the privilege of being part of the honoring of Judge Brody. And I'd like to thank Nancy Gertner for being my interlocutor. There's no one better at doing that. One of the things that is relevant that was left out of Professor Franco's very nice introduction is I'm a lawyer as well as a psychologist. My primary affiliation is in the law school at the University of Pennsylvania, where I specialize in criminal law. So I come at this from both the criminal law side and from the scientific psychology and neuroscience side. Now, many people think that neuroscience, based on non-invasive brain imaging, will transform how we view ourselves and our institutions, such as the law. Take, for example, the following editorial statement published in The Economist back in 2002, so 16 years ago, quote, "Genetics may yet threaten privacy, kill autonomy, make society homogeneous, and gut the concept of human nature. But neuroscience could do all those things first," end quote. Well, that's pretty scary. But what I'm here to tell you is neither neuroscience, nor genetics, nor any other science that was predicted to revolutionize society and the law has had this effect. Neuroscience is simply the newest science on the block, and it's unlikely to produce the results the economists fear, at least for the foreseeable future, and my guess would be never. At most, in the near to intermediate term, neuroscience may make a modest contribution to legal policy and case adjudication. Nonetheless, there has been a rational exuberance about the potential contribution to legal policy that I have termed brain overclaim syndrome. It's virulent. Although I have prescribed a safe, effective, inexpensive, non-invasive treatment for this dire condition, which I have termed cognitive gerotherapy, it simply requires learning the limitations of neuroscience and the conceptual and empirical relations between neuroscience and law. So the reasons for neurohype, and the title of this talk is, if I were to give it a title, Neurohype and the Law, a Cautionary Tale. The reasons are conceptual and empirical. Let's build the argument from the ground up. Now, as everyone has said, I've got about 20 minutes, give or take. I was originally offered 10 to 12. So I'm going to take the privilege of thinking I have 20 to 24. All right? But I'll try to get it done in 20. And if you look bored, I'll leave stuff out. All right. Let's build the argument from the ground up. And for the lawyers in the room and the judges, you're going to just catch your breath, how breathtakingly superficial. What is law? Law, very simply, is a system of rules meant to guide behavior. That's its primary function. Law does other things, but what else does it do? It gives us reasons to behave one way or another. In this regard, law is like custom, it's like etiquette, it's like morality, it's like social norms. The major difference about law, of course, is we get to back those guiding principles with the force of the state. So that's what law is, essentially. Now, of course, we could go on for about 3 millennia discussing that, but let's go. What is the law's implicit psychology and concept of the person? Because this is a reverse inference. I look at what law is, I look at the law we have, and I say, what must be its implicit psychology and concept of the person? So here's what it is. It's what philosophers of mind and action and professional psychologists call folk psychology. Folk psychology is a causal explanatory psychology that explains human behavior in part. And I want to stress, underline 3 times, in part, because obviously other things are going on too, but it explains human behavior in part according to mental states. So let's give a folk psychological explanation for why you're all sitting in the room here today. You desire to honor Judge Brody. You desire to learn something about the relation of science to law. You desire to see your friends. You desire to go to a nice reception. You believe if you come to this event, the Brody Award event, all those things will happen, and you form the intent to be here, and here you are. That's how you explain yourself to yourself. That's how you explain yourself to others. And it is the psychology we all use, and it is the law's psychology. Because think what the law is doing. It's giving you reasons to behave one way or another. And the folk psychological creature is a creature who acts for reasons, as I've just described. Right? So law psychology is folk psychology. And I want to distinguish for you between folk psychology and folk wisdom. Folk psychology, once again, is a causal explanatory story about why we behave as we do, of the sort I just gave you about why you're sitting here. Folk wisdom is bits of empirical observations about human behavior that may or may not turn out to be true. For example, and the judges in the room will appreciate this, adolescents are different from adults on average. That may turn out to be true or not true. Okay, legal criteria are virtually all behavioral. By that I mean acts and mental states. And I'm not just talking criminal law, although that will be most of my examples, civil law as well. I mean, yes, there are criteria and regulatory stuff that have to do with how many parts per liter toxins may be in the water and stuff like that. But then if you look at when people are going to be responsible for doing that, it's their acts and mental states, strict liability aside, and even then you have an act requirement. So that's true, especially acts and mental states, when neuroscience is going to be involved, because then we're trying to figure out what is the person doing and why. So, the question of legal relevance is the first most important question. How precisely is the question? No hand-waving allowed. You've got to give a real explanation. Do the findings of neuroscience, or I might add, any other science or any other discipline, actually answer a legal question. It's what judges are deciding every single day they make an admissibility decision. Is this evidence that is proffered going to help answer a legal question in front of them? If it doesn't do that, it may be good science, it may be good clinical stuff, but it's not legally relevant. Here you have what Judge Gertner has talked about as the problem of translation. You've got a folk psychological enterprise, the law, and now you have a bunch of other disciplines that are not folk psychological. How do you do the translation from the one discipline to the other? Now let's briefly compare neuroscience to psychiatry and psychology. Psychiatry and psychology sometimes treat you like a hunk of meat. You go to your psychiatrist because you're depressed, and she gives you a pill. She's treating you like a hunk of meat. But if she's doing her job right, she's also going to ask you, how are things going in your life? How's your working? How's your loving? How are your interpersonal relations generally? She's going to tell you she's going to listen to you tell a folk psychological story about your life. The translation between psychology and psychiatry actually is not that hard because it is in part psychology and psychiatry, folk psychological. Neuroscience, by contrast, is purely mechanical. It is purely mechanical. There's no folk psychological neuroscience story. Neurons don't have reasons. The connectome doesn't have a sense of past, present, and future. The connectome doesn't have aspirations for how lives go well. Those are properties of full persons. Those are not properties of subunits or even of the brain itself. The brain doesn't do things. The brain is a hunk of organic jelly. People do things, all right? So, next point. Biological variables do not directly answer any legal question. Why? Because, by and large, legal criteria are not biological. The legal criteria are acts and mental states. So let's assume your question is, did mental disorder, such as addiction, or did a brain tumor play a role in this person's behavior? Did it cause this person, let's say, not to be able to control themselves? That's a behavioral criterion. That's not a brain criterion. You're going to have to show precisely how the brain findings translate into a behavioral lack of control. After all, biology is always at work. Your brain is being changed as we have this lecture. My brain is being changed by looking at the audience reaction. And if you persistently have a Colby College education for 4 years, your brain is going to be persistently changed. Okay. Now, there are two external challenges that neuroscience is said to produce, and I want to briefly dispose of them because they have absolutely no social or legal purchase yet. One goes back to your dormitory arguments when you were in college. Gee, if determinism is true, how can anyone be responsible? And doesn't neuroscience prove at last that determinism is true? Well, first, no science can prove determinism is true. It's not the kind of question science can answer. Second of all, there is a real metaphysical debate about whether responsibility is possible in something like a deterministic world. But there is a fabulously good answer. It's an unresolvable dispute, by the way. There's a fabulously good answer within the philosophy of mind, action, and responsibility called compatibilism. It says, even if determinism or something quite like it is true, robust responsibility is possible. Not godlike responsibility. You can act uncaused by anything but yourself. No one can do that, not even judges and law professors. But nonetheless, we can still have enough robust responsibility based on our capacity for rationality as human agents. So, moreover, I would suggest the law as we have it is most consistent with that metaphysics. There's another more radical challenge. That is that we're just a pack of neurons. That's associated with Francis Crick of Watson and Crick, the discoverers of the double helix. Or in more contemporary terms, we're all victims of neuronal circumstances. Well, welcome, my fellow victims of neuronal circumstances. The idea being, we're not human agents at all. Our reasons do no work. Our intentions do no work. It's all happening at the neuronal level. Now, serious people make this claim. It would take me a long time to go through the arguments, but here's what I can tell you. There is no empirical or conceptual reason to believe that today. This is all blowing smoke in my view. So now let's talk about, I've talked about the conceptual problems, the problem of translation from this completely mechanistic science to the legal questions. Now let's talk about the empirical problems. Here there are two major obstacles. First, there have been astonishing advances in neuroscience since the discovery of non-invasive functional imaging in 1992 in a laboratory in Harvard Medical School. The scanners, called magnets, started coming online in large measure in 2000, so we've got about 18 years of science here. There have been astonishing advances. Despite the astonishing advances, we know a whole lot less than the brain overclaimers claim. I mean, they're very sick puppies. Oh well. The second major problem is this. There have been almost no studies done in neuroscience to address specific legal questions. Because, and for those of you in the room who are scientists who try to get your funding from various sources, there's not a box for legal questions. Not in neuroscience, not in psychology, nowhere, which is why MacArthur made such a big difference in neuroscience and law, because they're not the NIMH, they're not the National Institute of Drug Abuse, they can fund whatever they want. Okay, I'm going to discuss these two problems in order. And note what I'm talking about is not largely neuroscience at the cellular level or subcellular level. I'm talking about the kind of neuroscience that would be relevant to law. Behavioral neuroscience, basically cognitive neuroscience, social neuroscience, affective neuroscience. That's the kind of neuroscience I'm interested in. First major problem, we have no idea how the brain enables the mind and the action. We know that it does, but we don't have a clue. And by the way, I say this to rooms full of neuroscientists all the time. No one contradicts me. This is the hardest problem in all science. You have this human brain is about the size of 2 average adult fists. It's 2.5 pounds of organic jelly that basically does electrochemical, physiological transformations. How does that material hunk of gray and white jelly produce consciousness? How does it produce intentionality? How does it produce action? We don't have a clue. Now, does this mean good research is impossible? No, but it sure as heck hinders it. Second of all, most neuroscience studies have very, very few subjects. For the scientists in the audience, what you know that means is very low power. In other words, you can't be very confident of the results when you have 10 or 15 subjects in a study. Thirdly, research design in behavioral neuroscience is particularly difficult and often makes results from the studies very difficult to draw inferences. It is extremely difficult. New artifacts, new uncontrolled for variables are being discovered all the time. New methodological problems are being discovered all the time. This is a major stumbling block. Most of what we know is not causal, and it's not fine-grained. Most of what we know is simply correlational, and it's coarse. When you see in the newspaper, such and such a region is the platform for, or you see any language that suggests this region of interest in the brain, what's known as an ROI, this region of interest in the brain causes a particular behavioral outcome, people are once again blowing smoke. Basically, we just have correlational talk. I once asked an eminent neuroscientist, because he knew this, why he used causal talk. He said, that's the way you get your papers published. Okay. There's a major problem. This is the ability to generalize from laboratory artificial findings to the rough and tumble of the real world. Does somebody's impulse control task while lying there in a scanner and deciding between carrots and marshmallows on a screen, does that predict whether that person's going to be a mugger in the future? Moreover, who are the subjects of most cognitive, affective, and behavioral neuroscience studies? I bet you can all guess. They're college students, and they are not a representative sample of the population and not a representative sample, we hope, of felons. All right. Now we have, and this is a biggie. This is something I've identified in the literature. At least I think it's a biggie. It's what I call the clear-cut problem, and explains a lot. Neuroscientists do not go on fishing expeditions. They have already identified in advance some condition that they think is of interest. They've clearly identified it behaviorally. I now have a group of people with schizophrenia I identified behaviorally, and I now have a group of people without schizophrenia identified behaviorally. There's a clear difference between the two, and now I put them in the scanner, and let's assume I find some physiological difference between the two. It's going to be, by the way, a very small difference, even if it's going to be statistically significant. Now, did I need the scanner to tell me that these people were different when I'd already identified that they're different? Well, what happens when you have people who are closer together? There are the gray area cases. That's where the data are going to be a complete smudge. So where we're going to need the help in the non-clear cases, because remember, we're the law. We're interested in behavior. In the non-clear cases where we need the help the most, the neuroscience is going to help us the least. Here's what is maybe the biggest of biggies: lack of replications. This is now known as the replication crisis. It exists not just in neuroscience, it exists in medicine, God help us, and it exists in psychology. That is, when we have findings, how often has it been done in the same way to confirm that that finding is true? Would you want your health or wealth or freedom to depend on one study with 15 subjects? A recent review published in 2017 of neuroscience studies by biostatisticians suggested that probably 50% of neuroscience studies are wrong or not reproducible in one way or another. Now, none of this is surprising, and none of it is a rag on neuroscience for the following reason. This is a new science using new technologies that's addressing one of the hardest problems. In fact, some people think consciousness is the hardest problem in science. In fact, in philosophy, it's called the hardest problem. It's not surprising that we don't know that much yet. This is a really hard problem, and despite the astonishing advances, our tools are still quite crude. Now, there are a few studies recently that have addressed legal questions that show some promise. I was involved in one, a neuroscience study trying to show, for the lawyers in the room, can we get a neural marker that distinguishes between people who've experimentally been put in a state of knowledge versus a state of recklessness? Basically, knowing to a practical certainty versus awareness of a grave risk that something is true. There have been studies using a neurovariable to help predict reoffending. There's now a research program out there that is looking at whether we can get, and think how this would transform the tort system, we can get objective measures of how much subjective pain a person is feeling. Now, some of these are proof of concept studies. We're not there yet. None of these is ready for prime time. But none of these is going to, in any fundamental way, revolutionize the law. Now, what about the data so far? How much is neuroscience being used in actual criminal cases? We don't really know the answer to that question. You'd have to go out and look what's happening at the trial level. Those data are very difficult to collect, et cetera, et cetera. What we know from 6 published studies, 3 in the US, 1 in the UK, 1 in the Netherlands, and 1 in Canada, is that, as Professor Farahani, who can't be with us today, unfortunately, would have said, and has said in her apocalypse study of this question, it's a mess. And the reason, that's an exact quote, and the reason it's a mess is because the advocates and the judges, I'm sorry to say, haven't figured out the actual relevance of neuroscience to law. They haven't asked that basic question I suggest to all of you should be trying to answer. How precisely does this mechanistic brain stuff answer a behavioral, acts and mental states question the law raises? Okay, I'm going to leave you with a final notion that I think is crucial. Actions speak louder than images. Now, what do I mean by that? The law is interested in actions. It's interested in acts and mental states. It's not interested in brain stuff, except, and I'm now just really repeating myself, except as the brain stuff directly, relevantly helps answer a legal question. Well, what if you see a disjunct between neuroscience data and what you're observing about the subject or group of subjects' behavior? What you always have to do is believe the behavioral data unless there's some reason to think, let's say, the subject is malingering. Let me give you a simple example from physical medicine to make the point. Suppose a worker's been in an industrial accident and now claims suffers from disabling back pain. What do we know about the relation between abnormal lumbar spine, lower spine, and back pain? It's very, very iffy. Many people with severe pain show normal spines, and many people with really miserable-looking abnormal spines have no back pain. But it's at least moderately confirming if our industrial worker has a bad-looking spine. But now the insurance adjuster smells a rat and wants to sort of investigate and finds that our hapless worker likes to exercise on a trampoline. I'm sorry, that person does not suffer from disabling back pain, no matter what his or her spine looks like. Let's take another example. If someone behaves entirely rationally, I don't care how abnormal their brain looks. They are a rational agent for legal purposes. Similarly, if we think a subject, let's say in a criminal case, before us is psychotic and not malingering, and by the way, brain science can't help us with who really has mental disorder or not, cannot be used diagnostically. But in any case, if someone is behaving psychotically, I don't care if their brain looks normal. For our purposes, they're psychotic. Last example. As most of you know, the Supreme Court, in a series of 3 cases between 2005 and 2012, decided that kids, basically juveniles, have to be treated differently for purposes of punishment. And we've known forever that kids are different from adults. And they're different behaviorally. They're more impulsive, they're more peer-oriented, they're more stressed out easily, and things like that. Rationality associated with developmental immaturity. Did we need a brain scan to know that? Did we need diffusion tensor imaging to show the adolescent brain is somewhat different from the adult brain to know that? And now I ask you the following question before I conclude. Suppose the diffusion tensor imaging, which is a form of non-invasive imaging, showed no difference between adolescents on the one hand, on average, and adults on the other. What would your conclusion be? Adolescents are indistinguishable from adults behaviorally? Or would your conclusion be the neuroscience just isn't sophisticated enough to pick it up yet? The behavior is what counts for us. So, my conclusion, much of what you hear about neuro and law today is hype. Is there hope? Yes, but not as much as those with brain overclaim syndrome would claim, and I wish they'd all get into cognitive neurotherapy. Thank you very much.
So, I'm going to, you should sit down, Stephen.
Thank you.
I'm going to open it up after I want to ask 2 questions because I want to sort of resurrect neuroscience here.
Needs it.
A little bit. So first, with respect to the cases that dealt with, that cited to the adolescent neuroscience. Yes, it was true that anyone who's ever had teenagers knew that they are different. There was no question about that. So this is a situation where the neuroscience actually gave concrete support in science for something we otherwise knew intuitively. And what difference did that make? Well, I've written about this in the Miller decision, which was the one in which the court said that there can't be mandatory life without parole for kids under the age of 18. But the court, it was very interesting. The use of the neuroscience is very interesting. In every other industrialized country in the world, there had been discussions about whether it is appropriate to sentence juveniles that way, as a matter of dignity, as a matter of norms, as a matter of values. We don't have that conversation in the United States very easily. The Supreme Court sort of said that, but also said, look at the neuroscience. It's almost as if we could have that conversation because it was grounded in science. Josh Buchholz, who speaks to my class, said this is using the neuroscience as a fig leaf. It may well have been, but it was transformative from one end of the country to the other. You don't agree?
I don't agree with that
at
at
your
all.
face.
I don't agree with that at all.
Okay.
You want me to answer that one? Let me take them seriatim, because I can't remember.
Okay, go on, answer.
All right, first, just for the lawyers in the room, I believe the citation to neuroscience in both Graham and Miller, which was completely vague, was dictum. They had everything the Supreme Court had, everything they needed in the Roper decision, and it was just dictum. Justice O'Connor once said to me privately, neuroscience was make-weight. The problem was nothing in the science since Roper had changed, nothing. So they didn't need the neuroscience. So did it have this transformative effect? I agree with Josh Buchholz that it was just fig leaf in this case because it was a vague citation and the court was ready to move in that direction anyhow. Now, Judge Gertner said something really important. She said, this gave a firm scientific grounding to the difference. In Roper, they cited excellent behavioral science. And I'm sorry to say, my friends, behavioral science is real science too. The distinction is not between neuroscience and other science. The distinction is between good and bad science of any sort and legally relevant science or not legally relevant science. Those are the two important distinctions. We already had a good, firm scientific basis. And I give you this. How long have we had an immaturity defense in the common law? 400, 500 years? How long have we had a juvenile court in the United States? Since the 1890s? Finding that the adolescent brain was different was a fig leaf, so I disagree.
Let me just counter for a moment on that. And I'm not sure that I'm responding in terms of the science. I think I'm responding completely as in terms of the law.
Rhetorically, yeah.
It was true that the court may have been moving towards that, but it was also true that the Eighth Amendment, which is the amendment that deals with cruel and unusual punishment, was tremendously contested in the Supreme Court, that for the most part the Supreme Court could only deal with the Eighth Amendment challenges when it had to do with the death penalty, and not even then very well. And so what we didn't have in this country that you had in other countries was a law about proportionality, weighing the offense and the offender against the nature of the punishment. And the court was all over the map. And to some degree, this fig leaf, this explanation that this is grounded in science, while it wasn't determinative, enabled. It was almost as if we can't say norms, values, dignity the way that other people talk about, but we could say this is grounded in the science. So it certainly crystallized something that may not have been moving in that direction. But to your point, the interesting thing about the Miller case is the science came in the briefs before the Supreme Court. Sure. There was no judge who presided over that science, which is very interesting, simply informed what was going on. But you do agree, this is why I'm saying I had to speak at the beginning, I'm going to put a question mark somewhere in this. You do, I mean, that decision, whatever its grounding, certainly led to changes in the way we look at life without parole all across the country. Led to the beginning of changes in the way, we look at now adolescents who are confessing very differently, and at least new rules so that there may be a reasonable adolescent rule as opposed to a reasonable man rule. In Massachusetts, there were challenges to the use of felony murder as applied to adolescents on the theory that the concept of felony murder, which is if you participate in the felony, you're held responsible for the murder, that broad doctrine doesn't enable a discussion of the kinds of things that adolescent development makes relevant. So it certainly had those implications, and it may have been a fig leaf at the beginning, but it's certainly done some good since then. Well,
what you're really getting at is what was motivating the justices. All right. I don't know what was motivating the justices. As I said, justice.
You should do a neuroscan.
Right, do a neuroscan.
That would be interesting.
If
there's any gray matter at all, but.
Here's the problem. fMRI doesn't tell you why. You know, it can't read the brain. But I don't think this is so. Judge Gertner. Let me say why. Let's take the Juvenile Confessions. Tom Grisso, a great forensic psychologist, has shown now for decades that adolescent confessions are less valid than adult confessions, and he showed this behaviorally. Now, who would have thought otherwise if you thought for a second about how adolescents are behaviorally different from adults? So virtually every way we want to think that adolescents are different, we already had the data from psychology or from sociology, which is very straightforwardly relevant because we're talking about human behavior. Now, how much did the neuroscience add to help crystallize this? Look, I think the Supreme Court was moving in its death penalty jurisprudence and its proportionality jurisprudence. I think you're right about that. I'm very glad they did move in the direction they did. I just don't think that, well, let me stop. I make a distinction between rhetorical relevance and real relevance. I think the neuroscience was rhetorically relevant. I don't think it was really relevant because it didn't add anything we know except in the following sense. It gave us another bit of confirming data. But suppose once again we discovered with diffusion tensor imaging that the adolescent brain didn't look different. Would anyone think the adolescent wasn't different?
The question, I suppose, is whether it would have concretized this movement.
You may be right.
And let me ask the other side of the coin. This is a discussion that we've had for some time, which is putting aside criminal law, issues of responsibility, in which the neuroscience is fraught because it, for numbers of reasons, which is that it really can't predict what an individual will do. It's usually identifying a brain in the past under experimental conditions and doesn't map easily onto, did this guy stab this person? You know, why did they stab this person on this event? But what about neuroscience and sentencing, which is what the reason that I got involved in this, which is that generally speaking, we would say that addiction had nothing to do with criminal responsibility. It may affect how a judge sentences someone. It's certainly whether it sort of enhances the behavioral discussion or whether it stands on its own. It certainly contributed to different conversations about what to do with addicts.
Neuroscience did?
Yes.
Yeah. I reviewed literally every criminal law doctrine with an eminent neuroscientist, looking at what neuroscience there was. This was in a volume I did called A Primer on Criminal Law and Neuroscience. And we concluded that except for a few well-characterized medical conditions, and nothing new neuroscience, like epilepsy, the neuroscience had nothing to contribute. A neuroscientist and a lawyer also looked at addiction and came to the conclusion that there was nothing in the addiction neuroscience literature that yet helped us answer these questions. So what I would like to suggest is, once again, there's nothing in the neuroscience, if you're going to use addiction at sentencing or anything else, that is really going to help answer the question except in a rhetorical sense. Here's the one possible exception. To the extent in a sentencing decision you're concerned with future dangerousness, which is a prediction question, then maybe a neural variable would help with making a more accurate prediction. Now, civil libertarians are by the way, can't do it yet, but at least in principle it's possible. Civil libertarians are worried about that. And by the way, this is something that also goes on in the civil justice system, prediction, for involuntary civil commitment, for example. Here's what I say to those who are worried about the civil liberties aspects of prediction. We've already decided as a society we're going to use predictions in civil and criminal law. What's the rational argument for doing it less well as opposed to better? And so if we really can make our predictions better, why not use a neural variable, assuming cost-benefit justified?
Last comment, and then we'll go to questions. There's a case pending before the Massachusetts Supreme Judicial Court now on this issue, which is a woman who was picked up for shoplifting. She was addicted for since age 8, a very substantial addiction. Neuroscience is not specifically involved. It wasn't that she was scanned. She's put on she's given probation, and as a condition of probation, she is to participate in a drug treatment program, be tested, and not use drugs. She participates in the drug treatment program, she's tested, and she's using drugs, and she's put back in jail. there was a very extraordinary public defender who wanted to take this on and who took the neuroscience, a very famous Harvard professor whose name I'm forgetting, to make the following argument to the court, which is that relapse is inherent in recovery from drug addiction. It is part and parcel of the, quote, disease. I know I'll get him angry with that concept. Part and parcel of the disease, and that therefore you should not be sending her to jail for something over which she had, and the rest of the sentence is not clear, no control, limited control, less control, but certainly not meaningful control, let me put it that way. And she shouldn't be sent to jail. That's now pending before the Supreme Judicial Court. Do you have any predictions? Or don't tell me you wrote a brief in the case.
I wrote a brief in the case.
I knew it. I knew it.
Yeah. First of all, her second charge wasn't for shoplifting. It was for grand larceny, and she fenced, and she was picky. And when they sent her back to prison after she tested dirty for fentanyl, they didn't want her to send her to prison. They wanted to send her to an inpatient treatment program, but they just couldn't find a bed. And as soon as they found a bed, she was out of prison. But then she claimed, I can't control myself. It's not fair to put me in prison even for a day for violation of probation. Okay. I wrote a brief with 3 addiction specialists on behalf of the Commonwealth of Massachusetts. We were joined by the National Association of Drug Court Professionals because the primary tool drug court professionals have for making their programs work is testing, and if you're dirty, we get to at least sanction you. And most of the addiction scientists were on the other side. Oral argument was October 4th.
No decision yet.
No decision yet. They are struggling because the Massachusetts Supreme Judicial Court likes to decide within 4 months. They have an internal court rule. They will decide within 4 months unless a quorum of the court says, we're going to extend. They've extended in this case. They must be struggling like hell. By the way, this is exactly the same issue that Justice Marshall decided against somebody like Miss Eldred in 1968 in Powell against Texas. It's the exact same issue. I've got a compulsion symptomatic of my disease of addiction. Let me off the hook as a constitutional matter. I think it would be a disaster, and that is said without any lack of sympathy for people who are struggling with addiction.
Now, questions. Who has any questions? Patrice, where are you? You have to start. Okay. You're going to call on people. Cold calling.
It's just like law school.
2 mic runners. So, Tim, please.
Thank you. I'm going to maybe deviate just slightly from the very specific question around law and science, which I think is really, really interesting. So thank you very much for that. But to ask a kind of more general question, because I think this issue, I think is endemic, not just in law, but everywhere, about whether our brains are good enough computers, as it were. And I certainly feel it in my work, for example, where, you know, I not only feeling not as good as some of my peers, I feel we're never going to be as good as the computer could be. So my question for you, Professor, is, and I guess I'm sort of asking almost to act as a psychologist or psychiatrist here, is do you think you said at some point, should we feel concerned about this? Because you said at some point, well, this is the hardest problem there is. It wasn't clear to me as to whether or not you believe or don't believe that, in fact, science can ultimately get there. So, in fact, we can perfect it. We're just not good enough. It's a simple question, but I wasn't sure that you had actually answered it.
Well, believe it or not, there's a whole group of people out there who are called Mysterians, believe it or not, who believe not that it's not explicable in principle how this organic hunk of jelly produces consciousness, intentionality, action, and the like, but it's just too hard a problem for unaided human beings to solve. I'm not a Mysterian. I don't know how hard it is, whether we'll ever be able to solve it or not. Well, I know it's very hard. I don't know whether we'll ever be able to solve it or not. Here's what I do know. If we are ever able to solve it, it will transform our view of ourselves, and not in ways that most of us will appreciate.
Any other questions?
You want to take a shot at that one too, Nancy?
Well, I mean, I think that some of the problems with neuroscience is that, in fact, scientists speak about groups, and law requires that we look at individuals. And the science that so far is not ready to identify individual variation to any great degree, which is why the advances, I would call them, have come in areas which are purely group, which is like juveniles under 18, which is like, confession issues. They're purely group to group. The difficulty comes in trying to translate that group data to individuals. Now, maybe the time will come. So, for example, with addiction, there may be a continuum of addicts.
Yes.
And there may be people as to whom this really was a voluntary choice initially, and it never is voluntary again, whatever that means, and people for whom there is choice at some point in this process. That could be meaningful to criminal law if we can figure out who's on that continuum.
Exactly.
Yeah.
I agree with that, by the way.
Phew. He agrees with that. I just want to pause. Yes. Go.
Because I think you're asking also a question about judging, I think, which is interesting, because it's the same question, for example, that I had in my business, and you had raised earlier the question of present value. We have this feeling that if we could only capture every possible contingency, that we would actually come to the right present value. I think that's actually, in some ways, the key question. So you're almost asking, can judges make right decisions or not? What is the right decision? And that seems to be almost a metaphysical question.
Well,
or not, I don't know.
there are two right kinds of ways of thinking about sentencing. One way is in terms of deontological theories of retribution. What does this person deserve? There's no tablet in the sky that will give us that. Then there are the consequential concerns, thinking about balancing off public safety versus the cost of public safety and all that. Here's what I tell my first-year law students, and they never know that I'm joking. I say, look, over at the Morton School, they've got a utilometer. What it does is it measures up quantities of utils, that is pleasure, pain. And what we do is we put in everything, every single possible cost and benefit of every decision, and then we solve for the social welfare function. And I do this straight-faced, and no one's laughing. It's really scary, because it's hilarious. It's idiotic.
Ryan, yes, we talk utils. Yes, good.
Well, just one other thing about that. The problem, and I'm sort of bringing realism into this as a judge, with respect to trials, there are rules as to when the science comes in, and presumably those rules will enable judges to be meaningful gatekeepers, although I have some concerns about that. Sentencing is the Wild West.
It really is.
There are no rules of evidence with respect to sentencing. The standard is the lowest standard we impose. The danger here, and the promise and the danger, is that this is going to be fought out in an area in which it's really quite wide open. I mean, I'm going through the cases that I sentenced. I'm writing a book on that, and I found one in which I cited to a brain tumor, which I've now learned is in a part of the brain that bore no relationship to anything with respect to this individual, and I had no idea, but nor did the lawyers involved. So the problem is that test in the criminal law, in a culpability stage, we can be careful, arguably. In sentencing, capital sentencing, but even in ordinary sentencing, it is dangerous.
Just for people in back in here.
Is it your position that there is no role for neuroscience to play, even posthumously? As an example, in the NFL, I know that's being litigated before the judge. In that litigation?
No, I think it's quite clear. If the question is, has there been brain damage?
Right, that's a different question.
That's a different question. And notice, that's not the new neuroscience. That's the old neurology. Maybe some of the newer techniques are helpful in identifying more fine-grained pathology than we would have otherwise been able to identify. But that's not the new neuroscience. So I think it's totally relevant, and I'm glad we have the techniques, whether on autopsy or any other way, to be able to identify the kind of brain damage that might have been associated with the behavioral changes we see. So I think it's totally relevant.
There may be a difference between sort of descriptive neuroscience and that which seeks to be explanatory. So descriptive would be, is there something wrong with this brain architecture? Is there a tumor? Are there things missing from it? That's a different use of it than using it for the purposes of trying to explain behavior. That's a very different. And the pain areas also I regard as descriptive. That's not explaining why you did what you did, but it may be possible, perhaps sooner rather than later, to actually have neuroscience tell us whether someone is experiencing substantial pain. Now, whether it's pain that will keep you from functioning, we don't know, but it will that could well transform tort law.
Yes.
Where in the past you had to show you were in an accident because the law didn't trust the plaintiff to be honest about pain when there was no accident, nothing was sort of broken, nothing was split open. And there may be ways of identifying pain regardless of those kinds of indicators, and that really will be transformative.
One thing to note is there is no one-on-one necessary relationship between any particular brain pathology and behavior. So in the most important case being discussed in the neuroscience and law literature today about responsibility, the defendant had a huge brain tumor in the right orbital frontal region. And there was no doubt whatsoever this tumor was causally related to his particular criminal behavior. Well, what do we know about right orbital frontal tumors and behavior? They are a risk factor for antisocial behavior. But most people who have right orbital frontal tumors do not engage in antisocial behavior. Now, I'll tell you what is the #1 risk factor for violent crime, and it's biological. And not only biological, there's nothing you can do about it. It can't be fixed. It's called the Y chromosome. It swamps every other variable.
Sandy, and then we'll have one more after that, and if no one raises their hand, Thomas Lampert, you're on.
Thomas, you want me to take a long time while you're thinking? Nancy, you said sort of like this, that we now have rules when scientific evidence is admissible into the court. For those of us who are lay people, can you talk to us about those rules? We know, those of us again who are lay people, that the kind of evidence in the Brandeis brief was not acceptable in the 19th century. It certainly was in the 20th century. We know this. We're debating now. Where is that line, and how is that line drawn of when? Because scientific evidence always is talking about probability. Certainly social science evidence is.
I'll give you a 2-minute answer of what I write about. The Supreme Court, many years ago, and in the rules, invited federal judges to look at scientific evidence and determine whether or not it is reliable and valid. And the judge is supposed to be the gatekeeper. I was making a face because judges actually don't do that very well. And so what you have seen is, ironically, DNA took years to be able to be introduced when that was a science that had developed outside the courtroom in laboratories and then was used to apply here, which the neuroscience is as well. But the court was blocking the door until finally there was some change. On the other hand, we have allowed in forensic science, which has been absurd. In part, judges not determining reliability and validity, just going by precedent. So if some idiot precedent was established allowing bite marks, that's the classic. I mean, there's simply it's not a meaningful science. No one has ever tested it. And in fact, the premise that every bite mark is unique, you'll be able to tell who did it, is just not true. Never been tested. So what I was saying was hopeful that judges at least are being asked to be gatekeepers with respect to this in a regular trial when the standard is high. And but Daubert, which is the case that invited judges to be gatekeepers, doesn't apply at sentencing. So my favorite case right before I left the bench was literally, I was on the bench when there was an arson, when I was trying an arson case, and the first witness was the dog. I mean it. The first witness was a dog handler. who got up and said, "Billy is my dog. I've trained him for years." And he went to the scene of this arson, of this fire, and he snorted in a way that I knew to be a substantial sign. And then he's wagged his tail. I had a yellow lab at that point who would basically snort and wag her tail at peanut butter, you know? I mean, and I stopped the proceeding, and I invited the jury to have a bathroom break, and like it's 9 o'clock in the morning. And I turned to the lawyer and I said, "Are you going to challenge that?" And the lawyer said, "No, I'm good, Judge. I don't know what's going on. Nothing was challenged before." And then a case goes on and builds on the snorting Billy. And the guy is convicted, but the lawyer had done nothing about it, didn't know what the law was, didn't know what the science was. Ultimately, and I couldn't have a hearing with myself. I wanted to, but I couldn't. And he was convicted, and ultimately the case was set aside in a habeas proceeding, post-conviction proceeding on ineffective assistance of counsel. So the gatekeeping function of the judge is reflected in the competence of the lawyers and to some degree the engagement of the judge. So it's fraught, and and neuroscience is dangerous at that stage, but it's particularly fraught at sentencing.
So we're pretty much out of time, unless, Thomas, you have a yes? Do you have one? Yes. That's a good way to transition here. So I know one thing for sure, your dad, Mort, would have loved to be part of this conversation, right? This has been a wonderful, wide-ranging, spirited conversation about where the law might take us. And we're going to have more opportunity to think about these questions as we move forward at 5:30 to hear and honor Judge Brody, Judge Anita Brody. But for now, we have a short intermission. Out in the hall, you will find some sparkly things of various natures.
And you'll be tested on what is what.
You'll be tested on those. We'll be tested on those. So before we reconvene, if you like your seats, you can kind of mark your seats if you really want to. We're going to be back in this room. But please join me in a very broad round of applause for both Professor Morris and Judge Gertner. Thank you so much.
I should have known you were on the other side of Eldred.
Of course.
All right, so we're back in here in 20 minutes, folks. And for those who are visiting, just the simple things, men's and ladies' room are down the hall that way, okay? So good evening again. For those joining us, my name is Patrice Franco, and I am the Grossman Professor of Economics and Global Studies, and I direct our Goldfarb Center, which is very proud to be hosting the evening. Your formal welcome to our award to Judge Anita Brody will be offered by our provost and awesome professor of American Studies, Margaret McFadden. But that's going to be in a minute. Before I call her to the podium, we have a special opening this evening. Tonight is about the legacy of Morton A. Brody, a veritable force of nature, as father, husband, lawyer, and judge. The Goldfarb Center, with special thanks to Tim Dobbins, who is the guy walking around with the cameras there, right, who shepherded this project, has worked with the Brody family and friends to create a video that encapsulates the principles that guided his life. For those in the room who didn't have the honor of knowing Mort, the hope is that this will frame why we're here, to celebrate his exemplary career as lawyer, judge, and civic leader, and to honor a judge tonight, Judge Anita Brody, who embodies his qualities of integrity, compassion, humanity, and judicial craftsmanship. And for those of us lucky enough to know Mort, this will be a moment to recall his extraordinary characteristics that made us all feel so lucky to call him friend, colleague, mentor, father, husband, or family. Thank you.
judges are appointed and not anointed. And I try to follow that credo as I sit on the bench.
Morton A. Brody is an enduring public figure in the state of Maine. As a longtime resident of Waterville, dedicated civic leader, Judge Brody's legacy is one of integrity, dedication, love, and deep respect for the rule of law. The award bearing his name, the Morton A. Brody Distinguished Judicial Service Award, is given biennially to a jurist embodying these virtues.
From a very young age, Morton knew that he wanted to be a lawyer. And I think it is a wonderful thing for anyone when they end up in a career that just fits them to a T.
My dad had this uncanny ability to see the big picture without losing sight of the details. He had this ability to see how things fit together and how to zone in on matters that had the greatest impact in law and in life.
I learned everything that I learned about being a father and making sure that I put my family first from him. The good that I have learned from him over the years continues on in that next generation. He may not be here in person, but his spirit is here, and more than anything, his life lessons are here.
After a successful career in private practice, Morton Brody was appointed to the Maine Superior Court and later served as Chief Justice. He soon was elevated to Associate Justice on the Maine Supreme Judicial Court. In 1991, he was appointed by President George H.W. Bush and confirmed to serve as a federal judge on the U.S. District Court for the District of Maine.
You know, it's hard to identify all the attributes of a great judge. We think of things like temperament, intelligence, knowledge, diligence, fairness, sense of justice, presence in the courtroom, all of those factors. Judge Brody was the whole package.
He knew the law, but he understood human nature as well. And he was able to apply the law in a way that, while adhering to the very letter of the law, was always important. Equally important was understanding human nature, the people that appeared before him. He had a deeply profound sense of fairness.
It doesn't matter who you are, it didn't matter what you were, and it didn't matter what you represented. He would look at you as a mensch and treat you with the respect that you would hope every judicial member would.
Judge Brody's integrity, his commitment to excellence, engendered the loyalty and respect of his associates, colleagues, and those who worked for him.
He was just a wonderful mentor. The teaching part of the clerkship was very important to Judge Brody.
But I really think being around somebody like Judge Brody made it possible for me to hang in there. It's a very tough profession for women, but I owe him enormous gratitude for the support that he gave me.
The Morton A. Brody Distinguished Judicial Service Award was established at Colby College in 2001 to recognize the legacy of Morton Brody.
A great source of pride for us is being able to call the Brody family a Colby family. They've done so much for this institution. Judge Brody, of course, taught here. He mentored students for a long period of time. Judy Brody worked here in admissions and is still just a central figure in our life here at the college. We now have the third generation of the Brody family here at Colby.
The recipient is an outstanding state or federal judge. He had an important contribution to the development of the law, but had those same kinds of personal qualities that Mort had. Integrity, humility, and humanity.
Well, it's a huge honor, first of all, as you might expect, to be selected. And then secondly, for me, it reminds me of the role that family has played in Waterville, in the state of Maine, and the role that Mort played as a paragon, an example of what a judge should be here in Maine.
You talk to people around the state of Maine now. They talk about him with reverence, and they talk about him as somebody who
affected their lives in important kind of ways. That's the legacy that the Brody Award is carrying forth, the legacy of a great human being who was a great judge and a great friend.
The courtroom was where he came alive and the law came alive with him. He was fair, and he had good judgment, and he was unselfish. And I think those are the qualities in Morton that people knew and respected, and he tried to do the right thing. And that meant doing the right thing by his family, his career, and his community.
All of us are human beings, but when we put on the robe, we have to recognize that we're dealing with other human beings' lives, or their property, or their rights. And I think we have to be very conscious of that. I think most of us are. When we put on that robe, we want to do the right thing. We want to do it with compassion. We want to do it in a way that we can look back on it and say we did the very best we could.
Such an important time to reaffirm why we're here to honor Judge Anita Brody, who will speak after her award is presented of her own personal journey through the law, and then we'll take some questions and answers. So to introduce Judge Brody, please, Provost McFadden, please come up.
Good evening. The Morton A. Brody Distinguished Judicial Service Award was established in 2001 in memory of Judge Brody. The aim of the award is to recognize in other judges the traits that distinguished Morton Brody: integrity, compassion, humanity, and judicial craftsmanship. We are proud to have counted Judge Brody as a member of the Colby community. He taught American jurisprudence here at the college, and of course was the husband of Judy Levine Brody, class of '58, who was for many years a member of Colby's Admissions and Financial Aid Office. So we want to especially welcome Judy and all the members of the Brody family. So glad you're here. I also want to thank the Brody Selection Committee for their service and diligence. That committee is chaired by the Honorable Nancy Torreson, Chief Judge of the U.S. District Court, District of Maine. Other members include the Honorable Robert W. Clifford, active retired justice, Maine Supreme Judicial Court. The Honorable Barbara Lynn, Judge of the U.S. District Court of the Northern District of Texas. Danielle Conway, Dean and Professor, University of Maine School of Law. Jamie Kilbreth, attorney at Drummond Woodsum. Elizabeth Brody Gluck, Judge Brody's daughter and general counsel at VinFen Corporation, mother of, I just want to say, 2 excellent American Studies majors. Just saying. And maybe a third. Amanda Cooley, former assistant director of the Goldfarb Center. Patrice Franco, Grossman Professor of Economics. Jennifer Lyons, law clerk to the Honorable George W. Single, and our own president, David Green. At a time in American politics when the Institute of the Judiciary, along with other foundational democratic institutions, are under fire, it's important for us to reflect on the fundamental values of compassionate, rule-based fairness to all, principles that were the North Star, you might say, for Judge Brody's career. To the judges and lawyers in the room, we'll recognize you more formally at dinner, but I want to thank you for your work in promoting the rule of law in our society. To the students aspiring to legal careers, we hope that you find the clear values of both Judges Brody, Mort, and Anita to be guideposts along your journey. Judge Brody, you're an inspiring example of how intelligence and determination of how intelligence and determination triumph over gender norms and stereotypes. A graduate of Wellesley College and Columbia University Law School, your path to the federal bench evidences your perseverance and your passion for the law, even though you began your career at a time when many fewer opportunities were available to women. Your professional journey has come to define your legacy, your belief that a personal life and parenthood should never be a casualty of professional ambition. As you've said, your family's more important than your career, but success in one area is not exclusive of success in another. After taking time to raise your 3 children, Lisa, Marion, and Timothy, who I understand is here with us today, with your husband, Jerome, you re-entered the legal profession, first in private practice in Philadelphia, and then with your appointment to the Montgomery County, Pennsylvania Court of Common Pleas. President George H.W. Bush appointed you to your current seat on the U.S. District Court for the District of Eastern Pennsylvania in 1991, and you were appointed a senior judge in 2009. From this bench, you have handed down more than 200 opinions, including widely publicized and highly influential rulings in the important NFL concussion case. The settlements you presided over in that case exemplify the compassion, fairness, and wisdom that have consistently characterized your work. Because of the respect you have earned from your peers and the legal community at large, you've been elected to the American Law Institute and received numerous prestigious awards, including the Medal of Excellence from Columbia Law School and the Sandra Day O'Connor Award from the Philadelphia Bar Association. We're grateful that along with your son Timothy and granddaughter Megan, that you have joined us today at Colby. Would you please come to the stage with President Green as I read the citation for this year's Morton A. Brody Award? Anita Blumstein Brody, known as a brilliant and fair jurist, a trailblazing woman, and a fierce advocate and mentor for your clerks, you embody the values of the namesake of this award, Mort Brody. Through your legal acumen, your compassion, your pragmatic decisions, and your devotion to equal justice, you demonstrate a commitment to the highest ideals of the legal profession. For your legacy that will continue to positively influence scholars and practitioners for generations, Colby College is honored to present you with the Morton A. Brody Award for Distinguished Judicial Service.
I want to be clear that I address my remarks to the students who are here this evening. I would be delighted to respond to questions at the end. Thank you for honoring me. Because I am a judge, 50% of those who appear before me adore me. They think I am a perfect judge. I was wise enough to rule in their favor. 50% dislike me intensely, and they are certain that I am pretty foolish. I ruled against their position. I appreciate that on this occasion, there must have been a modicum of consensus, and that alone is most reassuring. Thank you, I appreciate it. How nice it is to have a number of my judicial colleagues here with me today. Judge Nancy Torreson, Chief Judge of the Federal District Court in Maine. Judges John Woodcock and John Levy, also members of the Federal District Court in Maine. Is Stephen Vogel here? I don't think he made it. Okay. And I am delighted also to have Judge Morton Brody's daughter here, who is a friend of my daughter's, a classmate of hers from Dartmouth, and my son Timothy and my granddaughter Megan from Montreal. I particularly want to thank the members of the Colby administration who have been so very kind and welcoming to me, and of course, to the award selection committee who are honoring me today. I've had a chance to wander around campus. What a beautiful place this is. I also will take a moment to remember Judge Morton Brody, the person who is really being honored here today, and for good reason. The lawyers who appeared before Judge Mort Brody uniformly respected him as a solid and experienced and pragmatic judge with a good sense of humor combined with an outstanding sense of justice. Judge Morton Brody was a wonderful trial judge, even-handed, fair, and impartial. At the memorial service for Judge Brody, the then Chief Judge Brock Hornby said of Judge Morton Brody that as a federal judge, it was his responsibility to pass the judgment of the community on people who violated its laws and also defend people from an overwhelming government power. And Judge Brody did this with compassion, with grace, with humility, and with humanity. These are the most important qualities of a judge, and I am touched to receive an award in his name. My judicial career somewhat paralleled that of Judge Brody. Both of us were state trial judges for 10 years before going on to the federal bench. How much I would have enjoyed sharing our respective impressions. I will, however, tell you some of my thoughts and feelings about each. Before I do that, let me tell you a little bit about myself. The students should know that when I was in your stage of life, what it was like. Just a little history on what it was like at an all-women's college, Wellesley College, when I graduated in 1955. I was all of 20 years of age. In my senior year, it dawned on me that my father might not support me the rest of my life. I came from a comfortable middle-class family, and whatever I had needed through college was certainly with no assurance of the future. I was in a bind. A senior, and unlike most of the women, we were called girls back then, on my corridor, had no engagement ring on my finger. A ring was a key to future support, a husband. I guess in my heart of hearts, I believed that going to Wellesley would ensure me that at the end of the 4-year journey, I would have a man support me, preferably from Harvard or MIT. I had clearly failed. Panic set in. I tried to assess my strengths and realized that if I was good at anything, it was in math and numbers. I had pretty good people skills, but that was difficult to assess when I was 2 years younger than the rest of my classmates. Putting it all together, for some reason, the best option seemed to be business school. How I got there, I really don't know. In any event, I called Harvard Business School for an application and was informed by an admissions officer that the business school didn't accept women. I was floored. I can't believe what I did next. I asked that woman at the other end of the phone, did she have any suggestions? Yes, she did. I could apply to Harvard School of Management Training, rather Radcliffe School of Management Training. Radcliffe was a women's school of Harvard at the time. Management training, what was that? I asked that unknown woman on the phone what I might do after graduating from management training. She informed me that I could be an executive secretary to a business manager. A great help, I was told. That didn't sound too appetizing to me, even at age 20. I immediately decided I had better get back to New York City, where I would have a better chance of finding that man to put a ring on my finger. That was my history, how I ended up at Columbia Law School. I was the only woman in my Wellesley class to go directly to law school. At Columbia Law, we began with about 15 women in my class, 7 graduated. Last year, the Dean of Columbia Law School called me to inform me that I had been awarded this Medal of Excellence, given each year to 2 alums who represented the best in the school. That it was awarded in the past to such alums as Justice Ruth Bader Ginsburg and Eric Holder. I was overwhelmed. I started to cry. The dean was so surprised that she asked me whether I would accept. It all seems so unreal after such an ominous beginning. This brings you up to date with the addition that between the time I graduated from Columbia Law School and when I began my first judgeship, I found myself a husband, stayed home for a number of years to care for my children, and practiced law in the suburbs. As a judge, how does one spend time and what do we think about? My brother, who was a professor of law at Vanderbilt, and may I add, a friend of the two speakers that came before me, explained that he was fortunate to be a professor. He would think about anything he wanted to. I, as a judge, was constrained to think about what was brought before me. Under the United States Constitution, as the students probably know, to bring a case before a court, there must be a case or controversy. I am not permitted to simply opine on a topic. My job is completely dependent upon the nature of the cases that are brought before me to think about. I find that although there is certainly plenty of overlap, the issues I deal with now that I'm a federal judge are quite different from those I dealt with as a state court judge. In state court, I primarily dealt with state court issues, and in federal court, primarily with federal law issues. I will try to explain. As a state court judge, I presided over everyday intimate life concerns. For example, there were cases where two sides were arguing who owned a piece of property adjacent to their homes. At the beginning of the controversy, the two parties tried to resolve the dispute themselves. When the parties failed, it was brought to state court. I looked at the state court property law and rules who owned the property. This was a typical state court law matter. If a court of law weren't there to settle the dispute, it was always possible that the parties might not resolve it civilly. This process happened again and again. I adjudicated what rights a person had against a fraudulent car dealer and another alleged fraudulent real estate developer. Then there were, of course, the abundance of medical malpractice cases. I can recall deciding cases of one neighbor accusing another of throwing dirt over their common fence, and another about rights to a joint driveway. Then there was a mother who refused to take her child to Children's Hospital for her cancer chemotherapy treatments. Personal disputes. A judge acting in the role of a personal arbitrator, thus sometimes like a mother, other times like a teacher. My primary purpose was to resolve conflict peacefully between these types of opposing parties. As for state court criminal cases, I remember presiding over cases accusing a citizen of committing burglary, robbery, assaults, on a few occasions, even murder. All these crimes that we all feared, certainly immediately threatening to the victim. Again, I see it as personal in nature. The procedure in state court was less formal. Many more matters were decided in open court. Pretrial matters were less complicated. Adding to that was the fact that it was 1981. I was the first woman to serve as a judge on my county court. To describe what it was like when I ran in a campaign for the position, many lawyers and numerous citizens would ask me if I thought a woman could control a courtroom. Difficult to believe, huh? I responded that after raising 3 children, I thought it would be a piece of cake. Many thought the dome in the courthouse would collapse. Good news, it didn't. Life as a federal judge is very different. First of all, when a case is filed in federal court, there are a number of what are called pretrial motions, formal requests for the judge to immediately address the legal foundations of the lawsuit. These often require my writing an extensive term paper to justify my rulings. You see, I'm still writing term papers. It doesn't change. In federal court, I find myself resolving conflicts that are basically created by Congress. In general, I believe federal law is enacted to monitor society and achieve some societal end. The parties before me often seem incidental. Let me give you a few examples from my recent caseload. In the civil arena, what I am doing is carrying out a federal statute, such as one involving, for example, the failure of a company to pay its employees the minimum under the Federal Minimum Wage Act. The disputes between employer and employee arose because the federal law provided the illegality. A few weeks ago, I tried a case brought by exotic dancers against their employer, a gentleman's club. The dancers claimed that they were not receiving their rights to minimum wage. The jury awarded them damages, and the federal mandate to guarantee a worker a minimum was effectuated by a federal court. In another case, the city of Philadelphia has brought suit against one of the country's largest banks for their alleged discrimination in their mortgage lending practices. The claims originate under the Federal Fair Housing Act that dictates that this country will not tolerate actors in the housing market that deprive some citizens of the same rights to purchase a home as others. Another discrimination case involves a former manager of a car dealership that was allegedly fired because the organization was restructuring. The former manager claims he was fired because he was an older man. Again, we see as a country decided to give a job protection to its older citizens. Another woman brought suit because she was fired because she was pregnant, a protection afforded by our federal government to protect women in the workplace. Then there are the many, many constitutional issues. There was a prisoner who was suing under the United States Constitution, claiming the prison personnel were ignoring his constitutional rights when it ignored its medical needs. Another where the African-American prisoner was allegedly intentionally placed in the same cell with a known fierce bigot. We seem to be a country that places people in prison relatively easily, but does give them certain rights once they are there. Even our incarcerated citizens are guaranteed certain rights. In the criminal domain, the same themes apply. Our federal laws provide for the prosecution of persons when there is no immediate victims. For example, we have extensive racketeering laws to address mass corruption. I personally don't stay up at night worrying about whether someone was committing racketeering on me. The same principle applies to our drug laws. No immediate victim, but trying through our federal legislation to address a societal problem. When I look at today's governmental environment, it appears it may be that the only branch of government that truly operates is the federal judiciary. We do our job day in and day out. I love my state court job, and the adjustment to federal court on a daily basis, 25 years, it's now more than that, was difficult. But now I feel I may be making a difference, albeit in a small way. I am part of an institution with high professional standards that play an essential role in protecting and in fostering the American democracy. Let me explain why I feel this way. Early on, as a baby federal judge, I was at a judges' meeting in Washington, D.C., and toured the Holocaust Museum. When I returned back to my hotel, I was just sick. Noticing this, a federal district judge a seasoned one from Chicago saw me and suggested that we debrief each other on what we had seen. She pointed out to me that perhaps I had joined the one branch of government that might have had some impact on the horrors of the Nazi era. The German judiciary failed. Would we be upholding the rights of our citizens? I would like to think so. From where does the federal judiciary derive its power that I would even ruminate about such action? Let me return to my state court days for a moment. 36 years ago, the first day I served as a state court judge, the county sheriff paid me a visit. Remember, that was 1981, eons ago. This really happened. "Sweetie," Sheriff Fred said, "sit right down here. I want to tell you something." This huge hunk of man with a great big gun in his holster proceeded to assure me that while I'm the sheriff, no one in this county will violate an order of the first woman to sit as a judge on this bench. I looked at him, and I was absolutely certain that with this guy around, no one would dare violate any order of mine. There were lots of county deputy sheriffs around, and this proved true. 10 years later, I was appointed to the federal bench. I was transformed. How smart and powerful I became overnight. I soon realized that my gun-carrying county sheriff and his many deputies were no longer available to enforce my orders. I became what's known as a Wizard of Oz. My power rested upon the public perception of my power. No one was assuring me that my orders would be enforced. And you know what? Until very recently, unfortunately, fortunately, it never occurred to me that an order of mine would not be followed. About 20 years ago, I was fortunate enough to lunch with the former Supreme Court Justice David Souter, a judge from this federal district. The justice reported that he had just returned from a trip abroad. In Europe, the justice was asked whether Brown versus Board of Education was the most important case ever decided by the United States Supreme Court. Justice Souter responded that it was not. The justice explained that the most important litigation was over the Nixon papers. The United States Supreme Court ordered that President Nixon turn the tapes over to the federal prosecutor, the tape recordings that he had made while in the White House. Justice Souter explained that this was the most important decision because President Nixon, the President of the United States, abided by the order of the United States Supreme Court and turned over the tapes. This assumption is fragile, rarely addressed, but essential. Another important example of this tenet was the ruling in Bush versus Gore, the 2000 case when the United States Supreme Court basically decided the presidential election by ruling in favor of George W. Bush and over Albert Gore. The Supreme Court spoke out. Mr. Gore conceded. The ruling became the law of the land. There was no revolt, a message to cherish. What does this require? An independent judiciary that is strong enough to uphold the basic tenets of our constitutional democracy and a public that respects these judicial rulings. The citizens are the protectors of the law. That I am a small cog in the system is important to me. It even compensates for the joy I received in state court, thinking I would kindly resolve everyday problems. I know that you, the students who are here this evening, are fortunate enough to be attending a fine liberal arts college. You are thinking about what is in your future. Most importantly, you are encouraged to think and question. You want to know, how can I live a productive life? I was lucky I didn't begin with a purpose, and I ended with one. Perhaps this may happen to each of you. May you also have a hand in framing the issues that this country faces and enjoy doing so in the process. Thank you for listening. You want me to stay up here?
So, what's on your mind, folks?
You want to hear about the NFL case?
We do have runners coming down with microphones. So, yes, Maddie Glove, right here.
As a judge, how do you seek to find the balance between upholding the law that the citizens have created and upholding values that you think are important in our country?
That's the $64,000 question. It even outranks the professor's question. Absolutely. Because, again, I didn't necessarily agree with some of those decisions that I cited. But there are higher values, and I think we have to be faithful to the law. I have wiggle room. When I have wiggle room, I wiggle a little. But I think that there has to be certain tenets that you hold dear to you, and you have to abide by them. And Nazi Germany is a perfect example. When it is so deviant from what your basic tenets are, you have to give it a lot of thought. And there may be times that you do follow your instincts and what you think are important. It's very difficult. That's a very close line, a very difficult line, and one that you, as a judge, you have to take very, very seriously. But there are times, and I think that if I were ever faced with that, I don't know how brave I'd be, but I sure heck would want to be brave, because I think it's that important. You can ask. I may not answer your questions about the NFL case, but I'll... Okay, well...
Someone will ask. Wait a minute. What? Joe, I'm going to call it there, please. You're safe, Joe, right? You always have a question.
I recently had the chance to be judge for a day for the Maine State Science Fair, and different kind of judging. But one of the entrants was a student. He had actually tried this the year before and improved his entry to assess concussions for high school students or any kind of damage from having had an explosion. So I wonder your thoughts about, however the case should go, the implications for society even at that level.
Well, that is an interesting case. You have to understand that I, as a judge, that's not my job. I mean, I don't see that my job is, and I'm asked about this all the time. My job, frankly, as I saw it when I was faced with it, well, we have a settlement now, pretty much 20,000 former players. I saw my job as determining whether or not these players were entitled to a compensation because of cognitive problems, and what I was going to do about it, and whether I frankly could get the NFL to see it my way. And I was fortunate enough, and that's part of a job that a judge takes. This isn't a typical federal case. The main question in that case was whether or not I had any right to exercise jurisdiction over this. So that was the initial case. And when faced with certain problems that they might face in the future, that I might have made them very well aware of openly, the NFL decided to settle the case. And I thought that result was good for the players, retired players, because they would be compensated and were entitled to compensation. And also the NFL would have achieved some of the goals that they were interested in achieving. Whether it had this other effect, I'm not sad about it, but this wasn't you have to explain that it was not my motivating factor. Yes?
Judge Brody, one of the hallmarks of federal court now is that more and more cases are being decided on motion and without the kind of trial litigation practice that many lawyers got to experience years ago. I'm wondering if you have some thoughts about the fact that fewer and fewer practitioners are getting federal court litigation experience because the case is being decided on motion.
Well, I have to tell you that in state court, I tried cases all the time. I must have tried 20 cases a year. And if I try 2 or 3 civil cases, and very often not any criminal cases, because I'm senior, I have a reduced criminal caseload. I'm not sure. Litigation is so expensive now that many cases are resolved because the parties can't afford to go forward, and part of that has to do with the discovery process and a lot of other aspects of litigation. I think it's important to have some cases decided by juries because you want to have that input. You want to understand what a jury looking at this case would do. But at the same time, people. Somebody once said when I was a lawyer, one of my partners said to me that a good verdict is not as good as a bad settlement. And that's not untrue for anyone who practices law. They understand that that's true, partly because of the expense, and second of all, sometimes you can reach a solution that's good for both sides. I think I did, incidentally, in the NFL case. reached a solution that was good for definitely for the players, and I think for the NFL also. We obviously hit a lot of issues that Professor Morse and now Professor Gertner addressed. There's no question about it. We did, but that wasn't our focus. Our focus was in resolving this particular case in a way that was beneficial to both sides, and I think most people would think that it was. Yes.
Many of those types of cases would first have gone to mediation, and I'm just wondering if the NFL case did?
Yes, I ordered mediation.
Did it fail and then come to you?
No. What happened was they went to mediation, and because it was a potential class action, and they wanted the class certified. This is kind of technical. I don't want the students to understand. It's not important. If you come up after it, in order for it to be certified, I had to approve of it. They had put a cap on for $675 million. That sounds like a lot, but when you think of the number of players and the wealth of the NFL, I wasn't so sure that. And I turned the settlement down. And I said, I will not allow this. I don't know what the future holds. And I don't like any of the other constructs of what the future is going to hold. It didn't impress me, thanks to your kind of work that you do, Professor. And I said, I want an uncapped settlement. Now, that has strengths. I think it has all strengths, personally. The NFL sees, right now, I don't know if you've kept up with it. I don't know what Maine knows. But the NFL is claiming that there's a lot of fraud between lawyers and doctors who are conjuring up diagnoses that are inaccurate. And this is before me. I'm going to rule on it the next week or two. Whether and the NFL would pay for this, whether I am going to authorize this kind of investigation. The problem is that might stop some people who are entitled to get paid. So I have to, again, I'm weighing, have to weigh one against the other. But that does have if the NFL had a cap of $675 million, they would have washed their hands of it. They would have simply paid the money in, and they didn't care who got it. But now they have an interest, because it costs them a penny every time, or $1 million every time somebody is diagnosed. They feel very differently about it. And I can tell you from speaking with other judges down at what's known, at a conference for these kind of cases called Multi-District Litigation Conference, that this is something that worries the judges when you have a cap settlement, because they know they have to pay and they don't care, the defendant, the NFL in this case. So there are very few uncapped settlements, and I think after this, I don't know whether it's going to increase or decrease, but I think it should increase, because I think there has to be someone on the other side who says, no, this is just not the kind of, especially in mass torts, this is not the kind of case that we want people to get this kind of justice. All right, now I'm from Philadelphia. I next want to know who's going to win the Super Bowl. That's what I really want to know from you people. Okay.
I have no idea who's going to win the Super Bowl, but I'm struck by what you said about the attacks on the pillar of democracy, the free press, but more importantly here, the judiciary. So what would you say is the role and responsibility of individual attorneys and members of the judiciary to counter those attacks?
That's a very important question. Obviously, very, very important. And I put it in the hands, to a large extent, of the attorneys, because the attorneys the attorneys are prevalent everywhere now. Anywhere you turn around, there's some kind of some kind of lawyer that's involved in our whether it's congressional or whether it's state legislatures, and also just speaking out. The judges don't speak out. They do. Has to educate. They basically have to educate the public to understand that, how important what Justice Souter said, the few of us who were at lunch that day. It's just, if you don't have the public believing it, it doesn't work. And that's, frankly, very concerning at this time, because I hear a public screaming and yelling, and I'm not sure what they're saying. Not things that I particularly advocate.
I have a lot of questions, but I'll start with only one.
You can ask them later.
I'll ask them later. Is there any role for Congress to step in? I'm a trustee of an asbestos trust. After the asbestos litigation went across the country and it was clear that so much was involved, so much money was involved, Congress created this trust system where you've put aside a certain amount of money and then people make claims against it. And it seems to be working quite well. Is the concussion problem that kind of problem that Congress should step into? Of course, if Congress is functional, but I can say that now because I'm not on the bench. But in any event, would Congress step in?
I'm not sure of the role that Congress should have. I mean, this is a very different situation than I see it as an asbestos case, because there's a limited number of plaintiffs. They're retired players. So we have a much better idea of what the universe was. This is very different from the asbestos cases where we had no idea. We still don't have any idea of how many plaintiffs are involved in that. And the NFL we knew exactly how many. They have very good records. Wouldn't surprise you. Very good records of their former players. And if somebody says they played for 5 years, then the NFL says, no, he only played for 4. So we know all those things. And the only thing that's, of course, is a question mark is what the damages should be, what the injury should be. And that's, I've got a lot of people believing that I should have worried about CTE. And I'm sure that the professor would agree with me that I didn't think that was a terribly great idea.
Is there a last question? Michael.
What was the most interesting or difficult case that you've heard during your time on the bench?
Well, I don't know. It seems to me that I'm busy every day, and that's a nice question. Very, very interesting cases. I think that sentencing in general is one of the most difficult aspects of being a judge. And I love to find out what people think should be considered, because you'd be very surprised at what should be considered. People just don't really think about that very much. Should age be considered? Should, of course, what you raised today, what we call, should the drug, somebody's under the influence of drugs, should that matter? Most of the time, my answer to those questions, frankly, is no. So I think you got what, as one of my friends used to say, somebody said, schizophrenia doesn't excuse everything.
Well, I know that Judge Brody would be proud Judge Mort Brody would be proud to have had the first and last question by grandsons. So this is a good time to close out with great thanks. It's our honor to have you here this evening, to have your name entered into the list of Brody Award winners. It is an inspiring evening for all of us in the room to think about the importance of rule of law, and particularly in this time where the only thing we know is that it's defined by uncertainty, right?
That's right.
So thank you so much.
Thank you.
We love having you here.